Hi, my name is Blair McClanahan. I am one of the attorneys at the law offices of Cheryl David. I quite often get asked this question. My parent or loved one has passed away. What now? So I'd like to take a few minutes today and just go over that process in a nutshell so that you have the information to know your next steps. So first, if you have recently lost a loved one, please accept my condolences. This is not an easy time. And I want you to know there's not a rush. As long as your accountant is aware on the estate side, if it's been a few days or a few weeks, you are okay. All right. So what is the process of handling an estate? So let's start first by discussing when is an estate necessary and when is it not? So an estate, or going through a probate, as some people call it, is typically required when there is some sort of asset out there that was in a deceased person's name when they passed away. So sometimes this is a bank account or a stock or a car, something that was solely in the decedent's name and did not have a beneficiary or an owner with rights of survivorship. Oftentimes, if it's a married couple and they owned a house together, the good news is at the first death, there's really not a whole lot to do most of the time. Most of the time, real estate is owned between spouses as tenants by the entirety, which is fancy smancy for saying that everything goes to the surviving spouse. Now, if the surviving spouse has passed away and now everyone on the real estate is gone, or just a single person owned that property who's passed away, typically a probate will be required in order to sell the property within 2 years. Now, there's exceptions and loopholes, but this is typically the norm. Now, as far as bank accounts go, typically if there's a joint owner on the account with rights of survivorship, and you can find that information by looking at the signature page, those accounts don't have to go through the probate process. Or maybe there's a POD, a pay on death designation. Those don't have to go through probate, as well as trusts. Now, sometimes we have accounts that are solely in the deceased person's name. Those are accounts that will have to go through some sort of estate at the courthouse. Or maybe we have stocks or investments, or even in some rare instances, there's an IRA or a 401k or a life insurance policy that did not have a beneficiary or has one, but they've passed away as well. So in these instances, those types of assets will have to go through a process called an estate at the courthouse. Now, the estate's going to be in the county that the decedent lived when they passed away, where they resided. Okay. Now, for that process, if there's a will, the will get filed along with opening documents at the courthouse, and the court will issue something called letters testamentary. Now, sometimes we don't have a will, in which case we will file opening documents, and the court will then come back with letters of administration. These letters, whether they're letters testamentary or letters of administration, are an executor or an administrator's ticket into these accounts. Once the court issues these letters, then when we're doing a full estate for someone who has over $20,000, we have to run what's called a notice to creditors in the county paper where the person passed away. That notice runs once a week for 4 weeks. And creditors have a 3-month period where they can make a claim. So we urge our clients, don't pay major bills, hospital bills, credit cards, until that period's over. Now, the exception is real estate. We want to make sure your mortgage is paid, that your light bill, water bill, gas, electric, that all of that's paid. And if there's a car, we do recommend that any liens be paid during that period, as well as taxes on the house. At the 90-day mark, typically around the time that the notice to creditor period ends, we have to file an inventory with the court showing what exactly the decedent owned on their date of death. That gets filed, and the court's going to take a fee of $4 for each 1,000 on assets. Now, 9 out of 10 times, real estate's not going to come into play in this number, which is good for you. Um, that number also will not typically take into account beneficiary designated assets or joint owned assets with rights of survivorship. Those bypass the estate. Now, one weird little wrinkle is we still have to supply the court with joint accounts when we do our inventory. Even though they're not taking a fee, they do have a right to see those assets because, in theory, if claims come in, a portion of those assets are available to pay those claims. Now, when the process is done, which usually for a full estate takes about a year, more or less, we file a final account with the courthouse. We have beneficiaries sign receipts and we can divvy out the money. Now, occasionally an estate needs to stay open longer than a year, in which case at the year mark, a year from the day that those letters were issued, we will file an annual account. So that's a probate in a nutshell for an estate worth over $20,000. There's a shorter, more expedited program available for North Carolina residents that passed away with an estate under $20,000, or if there's just a car worth under $10,000. Now, there's different ways that we can protect your heirs from having to go through a probate, such as a trust. So if that's something that interests you, we highly recommend contacting our office for a complimentary appointment. I hope you have a great day, and thanks for listening to me.